Ms. Thomas, you leased a condominium that the defendant owned. You lived there, I think, for just a little over 2 years.
That's correct.
You described her in your complaint as a great landlord. So let's just start there. She said you're great, but after a couple of years, you needed to move. You got a new job. You gave the defendant notice on July 8th to tell her that you were moving out on August 10th.
Correct.
The defendant has refused to return the remainder of your security deposit because she says that you are required to give her notice on the 1st of the month. Your position is no, I gave you 30 days notice. So now you're not only suing her for the remainder of your security deposit, which I think is about $1,420, you're also suing her for something that you describe as hardship. I assume you're referring to the hardship of having to be a litigant in a case to get some money back.
Quite so.
Ms. Chugg, your position is that notice should be given on the 1st of the month because you can't rent one of your units in the middle of the month.
That's right.
You've complied with all of your legal obligations and you don't owe her anything.
Yes.
We'll just cut to the chase. There is a lease, but your lease doesn't say anything about notice having to be provided on the first day of the month. In fact, I don't even think that it says 30-day notice. That's just the amount of time that the law typically imputes to tenants. Like you got to get 30-day notice to kick somebody out. You got to get 30-day notice if you want to move out. That's almost by operation of law. That's not even in your lease.
Well, I consulted my attorney, which is in the exhibit.
Those lawyers are such bad people. So what you asked your lawyer was, does she owe me for the month or just the 10 days? It's more than the 30-day notice. And he says it depends on your lease.
But he also said that if it's month to month on the 1st, she owes from...
Well, rent may be due on the 1st, but he's also assuming notice must be given on the 1st, and that assumption is not borne out by your lease.
Can I just add one thing quickly?
Sure.
I actually started my lease on April 20th, in the middle of a month, when I moved to California from Georgia.
Is that true?
But she paid from the middle of April till the 1st of May. And then it says it in the lease that she went to a month to month. That's why we adjusted.
Month to month, respectfully, Ms. Chugg, I think you're confusing two different things. If the rent is to be paid on the 1st of the month, she's got to pay the rent on the 1st of the month.
Right.
If she has to give notice 30 days in advance, she has to give notice 30 days in advance.
Correct.
I think she's covered on all bases. But I still want to go back to you.
Sure.
The only way I would be inclined to give you money above and beyond the security deposit would be if you could show bad faith, malicious or intentional or horrible conduct. I don't see any evidence of that.
I actually sent her the legal proof in the email saying for the California Tenants Civil Code that this is what would happen. And it actually gave the exact example of giving your notice on the 10th and moving out on the 10th following. So I do think it was bad intent.
In fairness, her lawyer was telling her one thing, your research was telling you something else, so there may have been a legitimate dispute. So you're asking for too much.
Let me tell you what my thinking was when I put those amounts in.
Sure.
I'm now living in Long Beach. So to come from Long Beach up to Chatsworth, which is where the court was, on multiple occasions, I put in the mileage that I had to expend to do that. It's 47.5 miles.
Look, that is a drive I never ever want to take. I grew up in the Valley. I never want to go from Chatsworth to Long Beach in the morning if I don't have to.
Yes.
But still, the rule is not so much how hard was it to file. The first thing we have to ask, was she being malicious and acting in careless disregard of your rights? And that's a very different legal standard from just being wrong.